So today we're going to talk about sentencing. Specifically, when we look at sentencing, we're talking about the imposition of a penalty on a crime that of an individual that was convicted of a crime. If a criminal defendant pleads guilty or is found guilty by a judge or jury, then the judge and sometimes the jury may impose the sentence. There's four philosophical rationales behind sentencing. Just to know that the goals of criminal sanctions or criminal punishment are the prevention and control of crime. Always at issue is how best to achieve those goals. Historically, the four major rationales have been given for punishment include retribution, which there's slides on this, so make sure that you know what this is, but in some it's an eye begets an eye. So folks want to make sure that if you are harming someone, that the state gets to harm you back just a little bit more, and also falls into just desserts. And then incapacitation, as you can imagine, is locking people up. And then deterrence are really two different things behind this, is specific and general. Specific deterrence is the individual themselves were deterred, but more importantly than that, the system really likes general deterrence, which suggests that individuals, when they hear of somebody on the street corner that was picked up for drugs and that they were sent away for 5 years, that generally that whole community would know that they would hear that they got 5 years for dealing drugs. So they would be the more general ideas that they would be more likely to be deterred. So specific is for an individual, general deterrence is much larger community. And then rehabilitation is the idea that we help individuals. So the idea, rationale behind rehabilitation is that individuals that have committed a crime are lacking something, and we try and still sanction them accordingly, make them serve their time, but then allow them to come back to the community and help them with skills and job and things like that. And then when we go to sentencing, a little bit more in depth, judges are limited by the U.S. Constitution 8th Amendment to make sure it's not cruel and unusual. And these are guided by statutory provisions. And they are, again, guided by the prevailing philosophical rationales that we just mentioned above, also organizational considerations, pre-sentence investigations we'll talk about, and then their own personal characteristics. So statutory provisions is state and federal legislative bodies can enact penal codes that specifically state appropriate punishments for each statutory offense. 5 types of punishment that are used in the United States, and these are rank ordered from low to bottom. So the minimal sentence would be fines, and the next one would be probation, and the next ones would be intermediate punishments. These are more restrictive than probation, but less restrictive and costly than imprisonment. And then clearly imprisonment, and then death penalty, or what we also call capital punishment, to put somebody to death at the hands of the state. So within limits, judges can tailor the provision to fit the crime. They can combine punishments, so they can suspend a punishment. So what that means is that they could say, okay, we're going to give you 4 years probation and suspend that for 2 years. And if you do well in those 4 years probation, then that suspended sentence goes away. If you don't, then they will send you back for the full amount of time. So by doing this, it's hopeful that they can, the alleged defendant can stay out of trouble, make restitution, which is the fees, back to the court, and then seek medical treatment if and when necessary. So indeterminate, determinate sentencing is a pretty big deal. Indeterminate means that a sentence with a fixed minimum and maximum rather than a set period. So it's a range. So if on the front end your dad was going to prison and he was sentenced under indeterminate jurisdiction, you wouldn't know necessarily when he's going to get out. You wouldn't know if he's going to get out for your high school graduation or not. However, determinate sentencing is in fact a fixed period. And so the folks would say, folks that like indeterminate would say, your dad who's going to prison could do well in prison, and then that would allow him to get out earlier. So it allows him to have some motivation to do well. And then determinate sentencing, like I said, it's a fixed period, which eliminates the decision-making responsibility of the parole boards. So indeterminate, the parole board is the one that has the discretion. So it moves from the courts now to the parole board. It's based on the medical model of corrections, which was popular in the 50s and 60s. And the assumption is, one, that the offender is sick and the prison can diagnose the problem and help them. The prison can treat them, and the staff and parole board can determine if the inmate has been, in fact, successfully treated. And then determinate sentencing is that the law, it's the court then that sets the how much time that they do. And the law restricts the discretion of criminal justice decision making. The perceived advantage is uniformity, and presumptive sentencing allows judges some departure from the guidelines. Statutory provisions, there are 3 types of determinate sentencing. There's flat time, mandatory, and presumptive. And so flat time is just, does not include options for parole or good time. Flat time is just where the judges choose between probation and imprisonment, but they have little discretion. And once an offender is in prison, there's a possibility of no reduction. Where good time is the number of days deduced from a sentence by prison authorities for good behavior. So we used to do twofers, which meant that for every 2 days that you would do in a facility, prison, you would get 1 day back as long as you were on good stead within the facility and you were doing what you were supposed to be doing. So after flat time and good time, then we have mandatory sentencing, and this is where a specific number of years of imprisonment, the range is given, and then they get credit but don't allow them release on parole. Now, today's parole is definitely not looked upon in our current political climate. Historically, folks with good time could do for 7 years, they could do 3.5. Now, folks, the flavor of the general public does not want individuals to getting out in such a short amount of time, and they would in fact want individuals to serve at least 80% of their sentence, and that's called truth in sentencing. Mandatory minimum sentences, these are weapon violations, repeated drunk driving, drug sales, and drug kingpin laws. 3 strikes and you're out. So 3 strikes means that some states have 2 strikes, but a lot of states historically had 3 strikes, and then some have even backed away from it. So 3 strikes meant that if it was 3 strikes felony, you would have to get 3, and once you get 3 felonies, you're out. You're in prison for the rest of your life. And that sounded great for politicians that run on a tough crime. The problem is, which you'll see in the next 2 chapters, is that we can punish. We just don't have a place for them. So the problem when we do these mandatory minimum sentencing is, what do we do once we enact these and we don't have any gray area discretion to let them out? Then that means that we let out other individuals. So if you have a 3 strikes and you're outlaw on, bad check writing at the felony level, and you write 3 checks, that individual's going into a prison for the rest of their life. That sounds wonderful until the fact that you realize that you're having to let out rapists or other violent offenders because there's no bed. And then, like I mentioned, truth in sentencing, which is 80% of the time that they want. They want you to spend at least. To do at least 80% of your time for your sentence. And then presumptive sentencing is a compromise between legislatively mandated determinate and then indeterminate sentencing. So presumptive sentencing allows a judge to retain some sentencing discretion, subject to appellate as long as it falls within their realm. And then the legislature decides a range. And I would say that's probably one of the major reasons, one of the major things that happens today. So one of the major criticisms of indeterminate sentencing and a principal reason for the adoption of determinate sentencing by some states is judicial disparity. Judges vary widely in their sentences they impose for similar crimes and offenders. And so you'll see in this next slide, depending on who is sentencing them, what actually happened. So to be able to justify that, then they started saying, okay, well, in today's law and order climate, some legislatures increasingly replaced indeterminate sentencings with actually determinate ones. So like I said, that's more common today, is to have determinate sentencing. And some argue that determinate sentence results in longer prison and overcrowded, but at least folks can know when they're going to get out. So the criticisms of determinate is that the prisons have become harsher and they don't allow for rehabilitation anymore. The abolition of good time, or those twofers like I talked about, and parole on the back end makes discipline and control very difficult, because remember, anytime you're in a facility, the offenders are the individuals that are in control. So there's always way more offenders than there are correctional officers. So if you allow them some twofers or good time, or you allow them parole, then maybe they would behave better. Some judges ignore guidelines as they see as too harsh, and some judges that ignore them because they're too lenient. Determinate sentencing shifts discretion from the judges to the legislatures as well as prosecutors, because it's really tying the judge's hands. And then prosecutors still have discretion in plea negotiations, but they operate in secret, and then they give the judge at the very end the sentence of what they would want. So criticisms of determinate sentencing: in jurisdictions that retain good time, determinate sentencing shifts sentencing discretion, at least to some degree, like I said, and it's virtually impossible to define in advance all of the factors that ought to be considered to determine a determinate sentencing. So a judge's sentence is guided by plea bargains, so what is brought to him or her, prison overcrowding, and the cost of the sentence versus the benefits derived from it. I will say, though, that the judges do not look blatantly at prison overcrowding. So when they are sentencing, they are simply sentencing based on the merits of the case in front of them. They don't look and say, oh, how many are overcrowded in this facility, and I'll put them in this one versus that one. That does not happen. But the idea is that they understand that there's overcrowding, and so then that allows them to do other types of sentencing. So a prison sentence investigation, this is called a PSI. This is prepared on the front end of a sentence by a probation officer. They conduct a thorough background check on the defendant to try and get all the information necessary in a PSI to the judge. This allows for them to classify probationers, so to make sure, like if you're in a gang, to not put you next to a gang member. Are you a certain religious sect? Are you a sex offender? To put them with maybe additional sex offenders. So this classifying, and then also risk need, like what do you need? What are your risks? Do you need parenting classes? Do you need anger management classes? Do you need education? Do you need job skills? So all of this will come out in a PSI, and this is towards sentencing recommendations. And then allocution is at sentencing. After the PSI has been submitted, a sentencing hearing is held, and the defendant's allowed to participate in allocution. Not all will, but if they do, the defendant has the opportunity to plead for a pardon, to say, ask the court for forgiveness, and then other character witnesses are also will come forward during an allocution, and they have the right to be able to say that, well, this individual messed up, while they're not doubting the guilt, they're really just trying to tailor or minimize the impact of the sentencing. And then I have down here Brock Turner's statement to the judge. This was an individual from Stanford a couple years ago that was sentenced for rape, sexual assault. He had an allocution to the court, and it clearly worked because the court went ahead and didn't sentence him, Brock Turner, for as serious as other individuals would have gotten. So again, allocution. He or she is not the person. This is from the defendant's standpoint, that what happened was they were sorry for it. They went insane, or that they're pregnant. If they're pregnant during, they mentioned that they're pregnant, then they could potentially delay sentencing. Not always. It depends on the jurisdiction. And then appeals is something after the sentencing. So defendants can appeal their convictions on legal or constitutional grounds. So they can't appeal the case that they just heard because they didn't like the sentencing outcome. But if the defendant, once the defendant has been found guilty, and then the burden of showing why the conviction should be overturned is now on the defendant. So sometimes it could be maybe their lawyer was drunk during when they were serving them, or maybe something else in the sentencing process happened to make it be more difficult. So generally, an offender must file a notice of intent to appeal within 30 to 90 days after their conviction. They must file an affidavit of errors. So that's, again, you're not arguing specific specific items in your case. You're just arguing errors that were made within your case. Maybe the judge didn't give instructions for sentencing, or the judge allowed something in that they shouldn't have. So again, you're not arguing your merits of the case. You're simply just trying to say that something happened within your case that you wanted to appeal. And then the death penalty is reserved for the most serious, heinous crimes. It's also called capital punishment. And so for this one, we are one of few countries that put folks to death. So the first American settlers brought with them the English Penal Code, which listed 50 capital offenses. So capital punishment, capital offenses, and death penalty are all the same. And really, the earliest record of lawful execution was 1608 in Virginia, and there's been about 20 legal executions in the United States. Only 3% of women, and 2% of those 2% have been juveniles. And so the idea about capital punishment, it definitely has, it ebbs and flows with public opinion. Some states currently have no death penalty, or they've stayed their death penalty, which means that they're not going to use it as a sentencing option. The Supreme Court did in fact uphold that lethal injection is acceptable and is not cruel and unusual as long as it goes according to plan. But the idea of death penalty is often back and forth politically. 5 methods to use. There is lethal injection, which is the primary type of use. So there's usually 3 drugs to that. One makes the defendant sleepy, and then the other 2 are the ones that stop their heart and have their system shut down. And then electrocution, so, pardon me, this is in a couple states still, so they need a natural sponge on the top of the defendant's head to allow for the currents to run through them. Lethal gas, so this is, they're in a chamber, and the gas overcomes them, and then they are killed from that way. Hanging and firing squad. Both of those are very unusual to happen today. So, Gregg versus, in the Gregg decision, without any evidence, they said that the new guided discretion statutes would eliminate the arbitrariness that they found in the Gregg versus Furman decision. The court was particularly optimistic because of what came out of this decision was bifurcated trials, guidelines for judges and juries, and then an automatic appellate review, which we still have today. So what we mean by bifurcated trials is it's a 2-stage trial consisting of first the guilt phase, which is completely separate from the penalty phase. So once a defendant is found guilty in the guilt phase, then at the penalty phase, the judge or jury must determine whether the sentence will be death or life. So what allows them to do is kind of take a breath in these capital cases, allow to say, yes, you've been found guilty, and then come back and decide if it's going to be life imprisonment or if it's going to be the death penalty. When we look at capital punishment, arguments against it are religious considerations, that we shouldn't be killing others. It's not our job to kill others. It doesn't, in fact, deter. So the idea about deterrence is that, well, if you trace it all the way back and say, well, Johnny raped and murdered an elderly person and did this over and over again, so Johnny's guilty of 5 of these rapes and murders of elderly individuals. And then because Johnny did that, then he's going to be put to death. Well, the problem is that is not directly correlated. So our courts take so much time, so it could take 10, 12 years to put Johnny to death. So the idea for deterrence, as you know from the beginning of these slides, is that it has to be swift and severe. So it's clearly severe and it has to be certain. And so it's not swift. So it really falls off on that deterrence, but it does make some people feel better to say that it's for a deterrence mechanism. Unfair application in that there's a bias, so there's a lot of history behind who is being put to death for similar types of crimes. So there's a racial bias and a gender bias, more likely to be put to death if you're a male, less likely for same type of crime for a female, and more likely to be put to death if your victim was Caucasian and you're African American. So because of these unfair applications to the death penalty, a lot of people do not support it. And then it is the violation. A lot of folks say that it's a violation of cruel and unusual punishment. So when the court found especially appealing about the guided discretion is that judges and juries are provided with standards that presumably restrict but don't eliminate their sentencing discretion. So judges and juries in most states are provided with a list of aggravating and mitigating factors. And so an aggravating factor just means that circumstances that make a crime worse. So an aggravating circumstance could be that you did other crimes, you've done multiple crimes, you've committed other felonious acts during a crime that you were just sentenced on. And then mitigating actually takes it away. So that's extenuating circumstances, saying that you have low cognition, low IQ, you didn't understand, you didn't know that what you did was going to affect you. So this sometimes, there's a Twinkie defense that you were hyped up on Coke and Twinkies, and so therefore you went crazy. There was multiple defenses that say that it was an accident, that you didn't have, intention. As you know, Malin say is that you had the intentional mind. So mitigating factors try and take away or limit why you did what you did, try and explain away, where aggravating make it worse, to say that you knew and that it was it was an aggravating situation. You had thought about it, so a lot of a priori means that you've sat and wait and you've thought about it, you planned it out, and so that would definitely be an aggravating factor. So there is an automatic appeal. 31 or 32 states with the death penalty provide for an automatic appeal. Although the Supreme Court doesn't require it, some states have provided a proportionality review just to make sure that review in which the appellate court compares the sentence in the case it's reviewing with penalties imposed in similar cases in the state. Again, this tries to limit or at least address racial bias, inherent bias, to reduce as much as possible disparities. In addition to the automatic appellate review, there's a dual system of collateral review for capital defendants. These may appeal their convictions and sentences through state and federal. The issue with appeals, though, it takes a long time, and historically, the death penalty was more expensive than just holding someone incarcerated for their life because they were allowed to have limitless appeals. I believe that not the current administration, but the previous administration, perhaps under President Obama, they limited the number of appeals. So it's no longer endless. You can't just keep appealing and appealing and appealing. They've limited the amount of appeals that individuals can bring forward. Writ of habeas corpus, so some death row inmates whose appeals have been denied by the Supreme Court may try to have Supreme Court review their cases on grounds of writ of habeas corpus, and that is just bringing the body forward. The Supreme Court has significantly reduced the habeas petitions recently to reduce the delays. And so that's why I'm saying that I believe it was President Obama that really limited the amount of habeas corpus cases that you can bring forward, that you only have so many times that you can say you can start your appeal. Between 1973 and 2011, 36 of the initial convictions or sentences in capital cases were overturned on appeal. So that means, again, we're talking about putting someone to death at the hands of the state. 31 were overturned on appeal. That's a fairly decent number. Denial of what was that from? Denial of the right to an impartial jury. So something happened with the jury was not impartial. Problems of tainted evidence and coerced confession. So again, this begs back to the law enforcement, fruit of a tainted, they got evidence of a poisonous tree, that it was tainted evidence. Ineffective assistance of counsel. So like I said, maybe your counsel was drunk or unknowing, unaware of what was happening. And then prosecutors reference to defendants who refused to testify. So you know that now you do not have to testify. You don't have to incriminate yourself. But if prosecutors make intonations as to why you're not testifying and to suggest that the reason you're not testifying is because you're guilty, that is incorrect. So the death row population in the United States does continue to grow, but more slowly. A lot of folks have been removed from death row by having their convictions or sentences reversed. They've died of natural causes, been killed, or actually committed suicide, been killed within a facility, or they've received what we call computations, reductions in sentencing granted by the state's governor. And so computation can happen at any time. So, among Western industrialized nations, the United States is the only nation to employ capital punishment. Even when capital punishment is employed, most jurisdictions use it rarely or sparingly. The public support for the death penalty historically has appeared to be dropping. The American public is expressing greater concern about the way the death penalty is being administered, and that's that racial, inherent bias. 1997, the American Bar Association requested death penalty jurisdictions refrain from using the sanction until greater fairness can actually be meted out. So the idea is that leaders of most organized religions in the United States oppose capital punishment. World opinion increasingly opposes the death penalty, and the European Union requires the abolition of the death penalty as a condition for its admittance. On the other hand, capital punishment in some states has proven stubbornly resilient. Death penalty support among the American public remains relatively strong. The public is skeptical that capital murder sentenced to life without parole will remain in prison for life. The parole people believe courts and legislatures will be able to fix problems with the administration of the death penalty. Even jurisdictions that do not use the death penalty have not abolished it, really in case there's that one case that they want to bring forward. And although the death penalty has no virtual effect on crime, let that sink in, the death penalty has virtually no effect on crime. It remains a favored political silver bullet. And it really is a political, to say that they're tough on crime, that they support the death penalty. In our law and order criminal sanctioning today, the idea is, be as tough as possible, except we're killing people. So you can't bring that back in those cases where there's been DNA now utilized to say that, in fact, this wasn't the person, it was a coerced statement. So a simplistic solution to the crime problem used by aspiring politicians and law enforcement are just to say yes to the death penalty. So I hope I've given you some things to think about as far as sentencing and the death penalty in the United States.